All right, it's nearly 11:05, so I think we'll get started. And if anyone misses the start of the presentation, then I'm happy to say this is being recorded. The webinar will be available later on our website, and also copies of the slides will be available. So please do check that out later on, but also feel free to tell colleagues who maybe were unable to join us this morning, or anyone that you think might be interested in having a listen to this later on. Thank you to so many of you for joining us this morning. We're really grateful to you for taking time out of what are no doubt very busy schedules. I've seen lots of very familiar names on the list of attendees this morning, and lots of new names as well. So welcome. Sorry we can't see you in person, but we're glad that you're seeing us. My name is Tara O'Leary. I'm a member of Cornerstone Barristers housing team, and I have the great pleasure of chairing this morning's webinar, which means happily for me, my three colleagues are going to do most of the hard work for me. But the good news is that you're in excellent hands. I'm absolutely delighted to introduce Christina, Olivia and Rowan. All four of us, as I say, members of the housing team, and also practice in a number of Cornerstone's other key practice areas, essentially various different areas of public law and local government work. I suspect Rowan, Christina and Olivia are known to many of you already. They've spent the last few months, as we move out of the pandemic, developing very busy and growing housing practices. So I did want to say that I think many of you do know that Cornerstone's housing team, in addition to possession work, we do all sorts of different landlord and tenant and social housing work. So managing ASB in all sorts of different ways, looking at mental health and Quality Act issues. We have quite a strong overlap between our housing team and our community care and court protection practitioners as well. We do housing and homelessness allocations, we do disrepair, housing conditions, and lots of work under the Housing Act 2004, including houses and multiple occupation, additional and selective licensing. So I'm going to take the opportunity for a moment of shameless self-promotion, and do please encourage you to check out our website, because there's a wealth of resources that we've built up over the last year. We've done lots of previous webinars, and they're all recorded and put online. We've had several updates on possession, but also other topics that might be of interest, particularly public law defences, disrepair. We've done tenants using properties for a Airbnb, and lots else besides. And we also have our webinar, our housing newsletter, which we put out twice a year and is online. We will be having further webinars coming up over the course of this year. Please do keep an eye out. I'm also very pleased to say that our annual housing day is going to go ahead, most likely in October. We're still working on the format, but I suspect that at least some of it, if not all of it, will be online, which might be particularly interesting for those who are based outside of London. So the save the dates for that will be coming out quite soon. So please do keep an eye on our website and Twitter. Now, that aside, I'm going to move on to introducing the outline for today's presentation, and I'll ask Olivia to move the slides forward. This is an area of law which is really in flux at the moment, as I'm sure all of you are only too aware. If we move on to the next slide again, we can see that there's been some really important changes over the last couple of months, in particular the introduction of the brand new breathing space debt respite scheme, which is going to be very important for rent arrears cases going forward. And Christina's going to talk to that. Olivia is looking at the end of the eviction ban, and of course we'll all be aware the government has rather unhelpfully repeatedly changed the rules relating to statutory notice periods and also the prescribed forms that need to be used. And that's an area, frankly, where I think there's likely to be scope for confusion, given different rules applying to different cases at different times. So Olivia is going to make sense of that for you. And then finally, moving on to some tips on practice and procedure from Rowan, because of course we're all still dealing with Practice Direction 55C, reactivation notices, and the other aftermath and backlog arising from the pandemic, as the county court is trying to grapple with that. So towards the end, we'll hopefully have some time for questions and answers. We're aiming to finish around 12 o'clock. I'm sure most of you are pros at Zoom by now. But towards the bottom of your screen, if you see the taskbar, there is a Q&A function. And if you have questions for us, please put them there. We may not be able to get through everything if there's a particularly lively slew of questions, but we'll certainly do our best to answer a few that are hopefully of interest. So with that in mind, I'll hand you over to Christina.
Thank you, Tara, and good morning, everybody. So I'll be talking about the Debt Respite scheme. So this is a relatively new scheme that local housing authorities, housing associations, and all other entities wanting to bring enforcement action, which includes, of course, possession proceedings, ought to be aware of. The relevant legislation is set out on the next slide. These regulations have been enforced since the 4th of May, so just over a month now. What I wanted to highlight first on this slide is that the government has issued 2 different sets of guidance for these regulations. One of these is for creditors and one is for money advisors. The most relevant one for most of you watching this webinar will be the guidance for creditors, and I've set out the link on the slide, and as Tara said, these slides will be circulated and made available online after the webinar. So you can access it via the link, or you can very easily find it via any search engine as well. The guidance is extremely well drafted and easy to understand, and I would encourage everyone to read it in their own time. It shouldn't take you longer than perhaps 20 minutes or so, depending on how fast a reader you are. So what is the Debt Respite scheme all about? In a nutshell, and this is set out in the second part of this slide, the regulations give qualifying debtors who access Financial Conduct Authority regulated debt advice or debt advice from local authorities a minimum of a 60-day window within which creditors may not enforce specified debt and may also not contact the individual about the debt, subject to exceptions, which I'll talk you through in a minute or so. This 60-day window is referred to as a standard breathing space. Now, seeing as there is a standard breathing space, what is the non-standard breathing space? That is the second type of breathing space, which is slightly more expansive and has different time periods. So this is for qualifying debtors in receipt of mental health crisis treatment. The idea is essentially that those people who undergo mental health crisis treatment don't have to apply via the standard scheme, but you can have mental health professionals, social workers, for example, you can get them to make referrals on the debtor's behalf. In their case, the breathing space and all that entails will last beyond the 60-day window and will continue for as long as the treatment continues, plus 30 days, subject to any more generous terms they might have in place with their creditors. Key distinction between the 2 types of breathing spaces is that under the standard one, a debtor can only apply for it once every 12 months. There isn't any similar limit for mental health breathing spaces. So there you could hypothetically create or apply for a breathing space more often than that. I stress, and then I'll move on to the next slide, I stress that a breathing space is not a payment holiday. So a debtor should continue to pay any debts and liabilities that they owe you, even though a breathing space has been created. In the housing context, this means, for example, that individuals for whom a breathing space is in place cannot be asked to pay arrears of rent for the property accrued up to the start of the breathing space. However, they should continue to pay you rent or any other liabilities that they owe whilst the 60-day window or the mental health equivalent is in place. The regulations also say that you cannot charge interest on rent arrears during the breathing space. So for either of the 2 breathing spaces, the mental health one and the standard one, a number of things need to be shown and put in place. And this is really the different things I'll go through on this slide. So the whole process essentially starts by a debtor seeking debt advice from a qualified debt advisor. And I previously mentioned that this can be an FCA regulated debt advisor or a local authority, and there are different referral options for the mental health equivalent. Qualifying debt can be anything from credit card bills to utility bills and rent arrears, and also government debts like tax and benefit debts. Qualifying debts can include any debt that the debtor had before the breathing space legislation came into force on the 4th of May this year. So it's not a matter of the debt having to have accrued after that period of time. It can be debt that accrued prior to that. Who is eligible? Anyone who cannot or is unlikely to be able to repay all or part of their debts. And there are certain exceptions for this. For example, if a person is subject to a debt relief order, or if they're in formal insolvency solution arrangements, they cannot create a breathing space. But apart from that, if you don't have these other arrangements in place, essentially the person applies to a debt advisor, a regulated one, or through the local authority, and the advisor will then assess whether they are suitable or eligible for the debt respite scheme. You, as the creditor, will receive a notification that somebody is in a breathing space. You will either be notified electronically, and that will happen through the insolvency service, about each debt owed to you in a breathing space and the date that the space started. If you don't receive the notification electronically, it can be sent to you by post as well. Electronic notifications are effective from the date that they are sent. For postal notifications, there's a four working day time period in place, and if a notice or a notification is left at your address, it will also be effective on the date that it was left there. As soon as you get a notification, the first thing that you're asked to do under the regulations is to search your own records to identify the debt owed to you by the debtor who has been identified by the notification. And I would recommend you to label or flag that debt so that you know the special rules that apply, which I'll talk to you about in a minute. You must also search your records for any additional debts owed to you by the debtor, which may not have already been captured by the notification, and notify their advisor should you identify any such debt. However, this will only become additional breathing space debt once a further notification is received. You must then stop enforcement action, and this is really sort of the main thing that I'll be talking about today. In particular, you must make sure you stop the debtor having to pay certain interests, fees, penalties, or charges for the debt during the breathing space. Any enforcement or recovery action to recover the debt by you or any agent you've appointed. So you cannot do that within that 60-day window or the mental health equivalent. And you also cannot contact the debtor to request repayment of the debt unless you've got permission from the court. I stress at this point that any action that you do take whilst the breathing space is in place that is not reconcilable with the regulations will be null and void, and you may also be liable to pay the debtor's costs in challenging that, and the debtor's advisor may also choose to take a complaint, for example, to the ombudsman or any oversight body or regulatory body. Finally, as for contact, generally during a breathing space, you must not contact a debtor, as I said, about any collection or enforcement action for a breathing space debt. So this will include asking them to pay or starting or continuing any legal action and sending them letters in the context of that. You can contact the debtor's debt advisor about the debt you are owed and try to discuss a debt solution, and that may be a very constructive thing to do. However, you cannot directly ask the debtor to take any steps to repay you. Any communications that you do send to the debtor should not show any interest, fees, or charges that accrue during the breathing space. Technically speaking, there is no breach under the regulation if you do show them. However, you're discouraged from doing that, and you can definitely not require the debtor to pay. Next slide, please. Thank you. So these are just a few important points from the guidance. I don't think I've copied them verbatim. Maybe, no, I think I've changed a few things, but under 3.6 of, so this is all from the Creditors guidance, what happens to existing legal proceedings. So if you had already filed a petition for bankruptcy or started any other action in a court or tribunal relating to a debt that is now in a breathing space, you must tell the court or the tribunal in writing. So that's the first action that you need to take after all the sort of preliminary points that I already spoke to you about with regard to going through the record, flagging any debt, potentially speaking with the debt advisor. You must notify the court, and you must do this as soon as you receive the notification for the breathing space. Where a court judgment or order has not yet been issued, court proceedings about the debt other than in bankruptcy proceedings and other than enforcement or court judgments or orders can continue until the court or tribunal makes an order or judgment. Types of hearings can continue. However, the vital point is that you cannot essentially enforce any orders or judgments. Next slide, please. 3.8, if a breathing space is created when there's already a court judgment or an order that has been issued, here the key takeaway point is that unless the court or tribunal gives you permission to continue, the court must make sure any action to enforce a court order or judgment about a breathing space debt stops during the breathing space, right? So you cannot hold any further hearings whilst the breathing space is in place. You cannot make or serve any orders, warrants, writs of control, anything that has to do with that judgment or order, and you cannot instruct an enforcement agent or bailiff to execute the judgment, for example. And then finally, you should also note that the court, if it has made an order or judgments for a breathing space debt before the breathing space began, that cannot be enforced during the breathing space either. Next slide, please. So what can you do if you think there's something incorrect about a person having been granted a breathing space? You can ask, first of all, for what I would call an internal review. So you can ask the debt advisor to review the breathing space, or say that specific debt shouldn't have been included in it. That must be done by a written statement within 20 days of the start date in the initial notification, or within 20 days of any additional debt being added to the breathing space. Remember, I said that if you see on your record, for example, that there's another debt that ought to be included, the starting point is then 20 days, the relevant time period is 20 days after that a moment in time. And if the debt advisor decides not to cancel the breathing space, they will tell you about the decision, and you can then, if you think that's the right thing to do, take action by applying to a court if you're not agreeing, and that must be done within 50 days. Okay, we're coming to the end. So the next slide, please. What does all of this mean for possession proceedings? You cannot start any action or legal proceedings, obtain a warrant or a writ, get or seek a liability order, sell or take control of the debtor's property or goods via a bailiff, serve a notice to take possession of a property on the grounds of rent arrears due up to the start of the breathing space, and you cannot take possession of a property let to the debtor having served such a notice prior to the start of the breathing space. So this applies for all of the different rent arrear grounds. However, and I've highlighted this with the two errors here, you can still seek possession on other grounds, but note that there may potentially be an overlap with mental health, for example, if you're thinking ASB grounds. And a breathing space does not stop the Section 21 eviction process for a short hold tenants. So you can still rely on that, even if there are rent arrears that are the subject matter of you trying to seek possession. And then the final slide, I hope. I think I might skip over this. Essentially, you'll be sent a notification when a breathing space ends. I have one concluding slide. So I think just try to take away the following. There's more to read on this, but I think this sums it up pretty well. A breathing space does not extinguish debts or displace any ongoing liabilities, but it does prevent enforcement action against debtors for as long as the breathing space is in effect, including the taking of possession action. A debtor cannot be asked to make further payments or pay any interest, fees, penalties, or charges arising during the breathing space, and you must essentially apply all these different protections until you've received a notification that the breathing space has stopped. I would finally add that if a time limit for enforcement or for a new legal claim related to the debt ran out during the breathing space, so essentially a limitation problem arises, this is then extended by a further 8 weeks from the stop date of the breathing space. So you will be given extra time to take any necessary steps that you might otherwise be barred from taking. And that's it from me. Thank you for listening.
Good morning, everyone. I'm now going to attempt to control the slides and speak at the same time, so I apologise in advance for any mishaps. I will be briefly outlining for you what the end of the eviction ban means, the latest changes to notice periods, and the changes to the prescribed forms that must be used now given the changes to the notice periods. The eviction ban was finally lifted on the 31st of May. So that means that for the first time since November last year, it's now possible to enforce possession. The practical reality, however, is that despite the fact that the latest eviction ban was placed in force in November last year, the reality is that evictions have not been possible for much longer than that. The original ban was lifted in September 2020, but given the localised bans that were introduced in accordance with the tier system, all in all, for the last 15 months, eviction has been impossible. So the good news for landlords is that as of the 31st of May, it is now possible for possession orders to be enforced as long as you have a valid warrant of possession. It's a requirement that 14 days notice of the date of eviction be given. So that means that even though the stay was lifted on the 31st of May, no evictions have actually been able to take place until the middle of this month. As with so many things in the last 15 months, it's a good news, bad news story for landlords. The bad news in this case is that because evictions have been prohibited for so long, there is, as you can imagine, a considerable backlog of evictions waiting to happen. So that means that even if you are a landlord with an outstanding warrant of possession, it's not necessarily the case that you will soon see a speedy resolution. Government guidance has set out a list of priority cases, which will be listed first. And as I've set out on the slide, those are ones involving antisocial behaviour, extreme rent arrears, trespass, domestic violence, and fraud. So if you have an outstanding warrant of possession and you don't fall within any of those categories, then unfortunately you are going to come later in the queue. Another potential hurdle that didn't exist pre-pandemic is the guidance that the government has set out about what will happen if a tenant that is due to be evicted informs the court that they or anyone they live with has COVID, is waiting for a COVID test result, or has been told to self-isolate. I've put up there on the slide 2 excerpts from recently published government guidance, and that guidance makes clear that an eviction will not be carried out in those circumstances. As you'll see there on the slide, if a tenant, for example, informs the court that they have COVID, then the eviction will have to be rescheduled to a later date, of which at least 14 days notice will be given. Bearing in mind what I've said just now about the length of the queue for evictions, you can imagine that this guidance means that there could be an even longer wait for landlords at the final hurdle. It's best to expect the possibility of this additional waiting period in order that if it does occur, you're not taken by surprise. And I hasten to add that I'm not for one moment suggesting that tenants will en masse begin making false claims of having COVID in order to delay an eviction, but it is sensible and probably pragmatic to be alive to the possibility of this happening in at least some cases. Notice periods. The notice periods have changed yet again, and that's both in relation to Section 8 and Section 21 notices. And the changes have been brought about by the rather snappily named Coronavirus Act 2020 (Residential Tenancies Protection from Eviction Amendment England No. 2 Regulations 2021. And these regulations amended Schedule 29 of the Coronavirus Act 2020. And they have changed the notice periods from the 1st of June to the 30th of September. And you'll see that I've set them out there on the slide for you. So in relation to Section 8 notices, as of the 1st of June until the 30th of September, the good news is that the general notice period has reduced from 6 months to 4 months. And that is for all grounds under Schedule 2, except those listed on the slide for which the notice periods are as I have listed them. And of the list that I've set out there, the one to take particular note of is that relating to grounds 8, 10 and 11. You'll see there that the requirement is now, as of the 1st of June, for rent arrears of 4 months when it was 6 before the 1st of June. And if you have 4 months rent outstanding, the notice period is now 4 weeks. For arrears of less than 4 months, the current position as of the 1st of June is that a notice given under grounds 8, 10 and 11 is subject to the 4-month general notice period. However, and again, as I've set out on the slide, you should take note of the fact that from the 1st of August, this will change. So from the 1st of August 2021 until the 30th of September, the notice period for rent arrears less than 4 months will be 2 months rather than 4, just to make things extra confusing for everybody. Something that does remain unchanged for once is that the notice, once the notice has been served, you have 12 months in which to issue proceedings. Now, you've already heard Christina's excellent and very helpful summary of the new breathing space legislation, and I don't want to repeat what she has just told you, but it is important to have those provisions at the back of your mind in relation to notices, because as Christina has told you, you cannot serve a Section 8 notice on a rent arrears ground during a breathing space period. However, and again, as Christina has already told you, you can still go ahead with a Section 21 notice or a Section 8 notice as long as you are only serving it in relation to a ground that does not concern rent arrears. Turning now to Section 21 notices. The changes here mirror those in relation to Section 8 notices. So from the 1st of June, the notice period has reduced from 6 months to 4 months. Also reduced is the period within which proceedings must be issued once a notice has been served. So as I set out there on the slide, from the 1st of June, proceedings must be issued within 8 months of service of a Section 21 notice, whereas for notices served between the 29th of August 2020 and the 31st of May of this year, you had 10 months in which to issue proceedings. So what's next? Well, the short answer is that in relation to both Section 8 and Section 21 notices, we're all expecting that once the 31st of September hits us, then we will revert to the pre-pandemic position in relation to notice periods. However, if we have learned anything from the last 15 months, it is to expect the unexpected. And so as the 31st of September approaches, and I'm sure it will be here in no time, given all the fun domestic summer holidays will be going on, I highly recommend that you keep your eye out for the government's announcements about what the changes will be to notice periods. As I've said, fingers crossed they will be reverting to normal so we can all give our brains a rest and not have to learn any new facts, but you should be on your guard that they may change. So with new notice periods comes new forms, which is very exciting. I'm sure you'll all agree. And it's very important that you make sure you're using the right forms, because not using the right forms for your notices is a very easy and very avoidable way of making your notice invalid. So like the notice periods, the forms have changed from the 1st of June to the 30th of September. The government has published the new versions of the forms on its website. And for once, the versions that they have published do actually appear to comply with their own rules. So that's something to celebrate, because those of you who have been serving notices in the last 15 months will probably be aware that there have been occasions on which the prescribed forms published on the government's websites have not actually complied with their own rules. But luckily, that is not currently the case. So if you're serving a Section 8 notice, you need to use the newly updated Form 3. And if you're serving a Section 21 notice, you need the new Form 6A. As I've said, you can find them in the usual place on the government website, but I have hyperlinked them on this slide to make your life easier as well. And it's really important that you use the correct template forms, because that's the only way that you can ensure that you're using the correct notice period. And in relation to Section 8 notices, there is a lot of information on the new prescribed form about the breathing space regulations. And so you need to make sure that you have that. Given all of the many changes that have occurred in the last year and a half, unsurprisingly, landlords often find themselves confused about whether their notice is valid or not. And in relation to Section 21 notices, I leave you with a top tip, which is that if you have a particular notice about which you are uncertain, maybe because you served it and then the rules changed, I direct you to a very, very helpful flowchart, which I've hyperlinked to on this slide. And it's a flowchart created by the Nearly Legal blog, and it contains a helpful guide to basically every question you could ever have in relation to all the different scenarios that might arise. And now it's the only thing left for me to do is to congratulate you if you're still awake, and to pass you over to Rowan for his insights into practice and procedure.
Good morning, everyone, and thanks so much for joining us today. I'm going to talk to you about some of the procedural and practical issues relevant to possession claims at the moment. And during the course of my slides, I'm going to refer heavily to Practice Direction 55C and to the documents Possession Proceedings, Listing Priorities in the County Court, and Overall Arrangement for Possession Proceedings in England and Wales, both of which are readily available online. And I've answered one of the questions with a PDF link to Possession Proceeding, to Overall Arrangements for Possession Proceedings in England and Wales already, so that link's in the Q&A. I want to start by turning to Practice Direction 55C, which modifies Part 55 of the CPR. As you know, that's the part of the CPR directly concerned with possession claims. Although I note that the duration of the amendment, which is called the interim period, only runs until the 30th of July 2021, having begun on the 20th of September 2020, which was the end of the stay imposed by Rule 55.29. That said, it's possible, in fact, very likely, the provisions will be extended. So hopefully they'll be useful beyond the 30th of July 2021. And the first important aspect of Practice Direction 55C is that it stayed all claims. It stayed claims, i.e., claims brought on or before the 19th of September 2020. Those claims, stayed claims, cannot be listed, relisted, heard, or referred until one of the parties files and serves a reactivation notice. And I've attached a link to a model reactivation notice on the next slide. I note that the requirement for reactivation notice doesn't apply to stayed claims brought on or after the 3rd of August 2020, or in which a final possession order has been made. So turning on to reactivation notices and looking at them in a little more detail, you'll see the link for the model notices hyperlink there. These slides will be on our website in a few days. Now, there's some essential content to a reactivation notice. The filing party must say that he wishes the case to be listed, heard and referred, and should set out what knowledge that party has as to the impact of the coronavirus on the defendant and on the defendant's dependents. If arrears of rent are a feature of the case, as it seems fairly likely they will be, the notice should be accompanied with an updated rent account for the previous 2 years. There is therefore clearly an emphasis on providing the court with updated information about what's been going on in the case since it has been stayed, what's the new position, and how has the coronavirus affected the defendant. Where there's no reactivation notice been filed and served by 4 p.m. on the 30th of April 2021, the claim is automatically stayed, and where there's been a trial date set prior to the 27th of March 2020, those dates will be vacated unless a party complies with the reactivation procedure not less than 42 days prior to the hearing date. So if there's a hearing date that you want to make sure goes ahead, ensure that you've complied with the reactivation procedure and make sure that you've done that 42 days before the hearing, at least 42 days before the hearing. Now, moving on to relisting. The court will provide at least 21 days notice to any of the parties of a hearing listed following service of a reactivation notice. If no hearing has been listed yet, the court will fix a date when the claim form is issued. Although, for obvious reasons, due to the likely overloading of the court system, the standard period of 8 weeks between issue and hearing no longer applies. Moving on to some case management issues. Just over the next slide, please. If there have been previous directions, a party filing and serving a reactivation notice must file, along with the reactivation notice, those previous directions that were made, new dates for compliance with directions, and a draft order setting out new or alternative directions that are desired, or a statement that no new directions are required. And alongside that, the party must also file a statement in writing as to whether the case is suitable for hearing via audio or video link. Now, if another party doesn't agree with the proposed directions or doesn't agree by, say, the suggestion that a video link is appropriate for the case, or objects, in fact, to the hearing being heard in person, they must then file a notice in response within 14 days of the service of the reactivation notice and the attached information that I've just gone through, the case management information. And finally, again, if these requirements to provide updates in cases in which existing case management directions have been made, if those requirements are not complied with by 4 p.m. on the 30th of April 2021, you guessed it, yet again, the claim will automatically be stayed. Now, there are some additional requirements for cases which have been brought on or after the 3rd of August 2020. In such cases, the claimant must bring a notice demonstrating it's complied with the pre-action protocol and saying what knowledge it has of the effect of the coronavirus on the defendant and dependents. And it must serve on the defendant, that information, not less than 14 days before the hearing. Why? To give the defendant notice of what the claimant will say, to give the defendant the opportunity to challenge anything the claimant has said, i.e. the defendant may not have received any pre-action correspondence despite the claimant stating that he provided that correspondence. And it may assert, in fact, the defendant may assert they've been more adversely affected by the coronavirus than the claimant sets out in the information they've provided to the court, so they may want to challenge that. So that's the requirement for notification of the defendant of that information 14 days before the hearing. And just moving to the other side of that slide, in claims to which section 2 of part 55 applies, i.e. in overview, that's short hold tenancies where section 21 procedure is used. The claimant must, along with the claim form, file a notice setting out what knowledge the claimant has as to the effect of the coronavirus pandemic, again, on the defendant and their dependents. So exactly how does the review procedure work once the court has all of this information? Effectively, there's a two-stage process following the reactivation notice. As you've heard, the court will provide 21 days notice of the next hearing. The usual practice will be to hold a review first and then proceed to a substantive hearing if appropriate. Now, normally, the review hearing will fix the date for the substantive hearing, although some courts will notify parties of both the review and substantive hearing in one communication. Either way, the substantive hearing will be 21 days after the review date. Importantly, the notice of listing for review will include details for the defendant of any duty scheme arrangements. So then 14 days before the review date, the claimant is required to provide the court with a bundle in electronic form, and you can provide paper as a backup. They're required to confirm to the court that a paper bundle has been provided to the defendant, plus an electronic bundle where the defendant can receive that. They're required to confirm that the bundle contains all the relevant material and to confirm that the claimant will be available during the review date to discuss case management directions with the defendant, duty solicitor or advisor. So the emphasis is therefore on the review date as an opportunity, an important opportunity for the defendant, having received or potentially obtained legal advice via the duty scheme service, to approach the claimant or consider with the claimant the prospect of settling the matter or at least narrowing the issues. And then the review date itself will be a very short hearing, 5 minutes, in which the judge considers the documents without the attendance of the parties, and the hearing will normally be at the end of the sitting day. But if the parties have resolved the case or agreed directions, it's an opportunity for the court to make any orders that are required. Where the case is not resolved by agreement, the judge will consider the bundle provided by the claimant and that information which is on the court file. If all the documents are in order, the court will proceed to a substantive hearing 28 days later, as I've said. If the claimant's documents are not in order, the court can be expected to either dismiss the claim or may give directions. So you can see here that there's potential for some delay in the event that the correct procedures have not been followed by a party looking to reactivate a case. I've set out all the relevant requirements in my slides. If you have any questions about the correct procedure, please feel free to email clerks in chambers and some will be available to help you to advise on what the correct procedure is. Moving over then to listing. As we know, there is, for the time being, no block listing anymore in the style that we've become familiar with prior to March 2020. I've set out a typical listing day on the right, including the end of day review hearing considerations, all of which are 5 minutes, and attemptedly the 10 substantive hearings set out throughout the day. I just want to emphasise that the guidelines regarding prioritisation, as you've heard, will remain in place, remembering that they're guidelines only. So that means that cases with allegations of ASB, extreme alleged rent arrears, and cases involving squatters or illegal occupiers will take precedence, and priority will also be given to claims issued before the stay in March 2020. I'm just moving over because I'm quite conscious of the time now. Moving on to tips, please. These are an amalgamation of the points which have frequently come up in my practice and from having spoken to a few other members of chambers. The first point is that Be sure that you're up to speed on reactivation notice procedure and the requirements of Practice Direction 55C, because failure to do so is likely to result in cases being adjourned, delayed, or stayed, as I've said. So if you want to proceed with possession case in the most efficient way, it's really important to make sure that you've complied with the relevant procedure. And of course, as I've said, members of Chambers are always around to help if you have any issues at all. And as you know, these slides will be available online relatively soon after this talk for reference. Second, the aim should always be to provide the court with the easiest possible document to understand. The bundle should really be numbered, indexed, and bookmarked. It's very helpful if it's word searchable. That can really help a judge readily understand your case, which is especially useful. You've just seen the possession list, where he or she has 10 substantive hearings and then reviews to get through. It just makes it significantly easier if the judge can very simply get to the nub of your case. And doing that is even more simple where the bundle is correctly organised. My third point, as ever, check with counsel, and it's never too early to do so if you're worried about anything at all, and that goes from procedure to merits. Is there an opportunity to settle the matter, recalling that the review hearing is an opportunity to settle or to narrow the issues? If so, do you need advice as to any offer? Again, counsel's always happy to provide practical advice as to what can be done. My next point, defendants may not turn up to a lot of the substantive hearings. It's very important that you can advise the court that the defendants received all the relevant documents and that they're aware that the hearing is taking place that day, because a judge, for obvious reasons, may be reluctant to order possession, particularly in the current circumstances, unless he's sure that absence is deliberate. My next point is that you should consider reviewing policies about the timing of notice. You've heard the very helpful talk from Olivia. It may well be that your policy about timing of notice needs to be reviewed. It may well be that they need updating in light of Practice Direction 55C, or indeed any further procedural changes which may be imposed in the future. It's worth just taking a look at what your policy is at the moment and making sure that it matches up with those points that we've gone through today. Ensure that you've considered the impact of the coronavirus on the defendant and their dependents, and that you can evidence that you've undertaken that consideration. It's important, the last part of that is important. You need to be able to show the court that you've undertaken those steps which the government has put in place to ensure that you are aware of the impact of the coronavirus on the defendant and their dependents. More practically, has the court got the correct details for any remote hearing? Is the defendant objecting to the use of a particular type of hearing? If so, has the type of hearing changed? But the headline point is to make sure that the court has the documents, the information necessary to contact you or counsel to make sure that you can appear at the hearing. I've had a few cases in which bailiffs have refused to carry out enforcement because they're unsure whether the ban on evictions is still in place or whether it applies on the facts of that particular case. Obviously, the ban is no longer enforced, as you've heard. If you're a local authority who's experienced this problem or who foresees this problem, there's nothing, in my view, wrong with asking the judge to record in the recital to a possession order that the ban no longer applies for the purposes of clarity. It may well be that a judge will refuse to do that, but in my experiences, some will, and there is, in my view, no harm in asking. Finally, and it's a simple point, simply make sure that you attend court early to maximise the opportunity to settle or narrow issues, which is much the same as it would have been before the coronavirus pandemic. And just finally, going over the slide, please, a few very quick words on the impacts of the end of the eviction ban on homelessness services. We know that there's going to be a sharp rise in applications for assistance. And my first point is that the current guidance urges authorities to attempt to liaise with those threatened with homelessness within more than 56 days, that being the time period for the engagement of the duty to provide assistance under Section 195 of the 1996 Act. Effectively, there's nothing preventing you from doing so, i.e. getting in touch with people more than 56 days in advance, and the current guidance encourages you to do so. It might be, looking further ahead, if you have capacity to do it, will allow housing assistance services to be more evenly spread out. The key will be communication with those tenants who the authorities suspects will be vulnerable to possession action, It may be you're able to assist them at an earlier stage and to prevent them from needing to engage in homelessness services later on. Now, in relation to homelessness applications themselves, thank you, consider early advice from counsel about applications, or indeed if you're getting lots of types of similar kinds of applications, which you may well do, would it be useful to have broad advice covering those kinds of applications moving forward? Again, it's likely that authorities will use more out-of-borough placements for affordability reasons, and I simply therefore flag that it is lawful to hold back a stock of in-borough accommodation if desired. But I also highlight that given allocation policies may be challenged, you should have a publicly available policy, again, explain the factors that you're going to consider just for the purposes of transparency and consistency. And finally, just remember, there is a requirement to house as close as possible to previous accommodation. You've got the case reference on the screen there. Now that's the end of my section. It's a bit of a whistle-stop tour through Practice Direction 55C and some attendant information. Unless there are any other speakers who wish to add anything to my talk, my section of the talk there, thank you very much for listening, and I'll hand back to Tara.
Hi, so I think all of us are involved in questions and answers. First of all, I should say thank you so much to Christina, Rowan and Olivia. I think those were really, really useful overviews, and the slides I hope will provide some quite useful resources once they're available online for anyone who wants a copy. So well done to you all. There's been a very lively discussion happening in the Q and answer section at the bottom of your screens throughout today's session. And I think although we've answered most of the questions, certainly in substance, although not necessarily every time somebody's asked them, sorry, because I know some of these questions have come up more than once. I'm also mindful of the fact that I think technically Zoom does not allow us to save or to reproduce the answers, and we can't make those available after today's session. So if anyone wants to quickly refer to the Q&A answers, you'll see there's about 19 there in total, and you can maybe take a brief note for yourself for the next few minutes of what we've said. Now, I think one issue that has kept coming up over and over again in the questions relates to eviction warrants, and two questions have come up in relation to that. And it may be that it's useful just to briefly discuss them in case anyone has not seen our answers. The first is whether or not there's any onus or obligation on the landlord to give notice to the tenant of the date of eviction. And Rowan has answered this in terms of a written answer. I've also chipped in. My own personal understanding was that yes, you must give notice, and it's about 2 weeks notice, but the responsibility for doing that rests with the bailiffs. Particularly at county court level, it was always the court and or its bailiffs which sent out notice to the tenant. It may be that the situation has changed for High Court enforcement agencies. I have a vague memory that High Court agents weren't previously required to give notice of their forthcoming eviction date, and it may be that has now changed, although I've not been able to lay my hands on any specific rule changes over the last hour. Rowan might be able to correct me. I think
it's an amendment to Rule 83.8a of the Civil Procedure Rules, amended by Rule 3a of the Civil Procedure, Amendment number 5, Coronavirus Rules 2020. It may well be that if this is an issue that comes up in practice, that you want to seek more specific advice, but the notice of eviction must be delivered, and that requirement applies to both the County Court and High Court enforcement. So I think Tara's right.
So sorry, you'll have seen I had a brief interruption there. Yes, thank you very much, Rowan. That's the change I was looking for. I know that there has been, for example, there was a reported decision that Andy Lane in our chambers was involved in last year, which is on Westlaw, and that's the case of Davies in Hertfordshire, where Mr Davies was evicted without any notice by High Court enforcement agents and tried to have the eviction set aside or undone on that basis, unsuccessfully, I should say. But that's helpful. I think Rowan and I, in the written responses to these questions, both suggested that while there isn't a specific requirement on the landlord in terms of any court rules mandating you to give notice to the tenants, it's clearly advisable to do so, because if the bailiffs muck it up, then you don't want to be in a position where the tenant might succeed on a stay application purely on that basis. Because I think, frankly, the point is that they get 2 weeks notice as opposed to who gives it to them. So if in doubt, let them know. You'll never be criticised for doing that. The second question, which was coming up in relation to warrants of eviction, was, I imagine, a very common scenario, which is you got your possession order perhaps pre-pandemic. You had a warrant originally issued more than 12 months ago, and the courts are now telling you you need to apply to get a new warrant. And many people are saying they've been advised by court staff in response to applications to enforce warrants that if it's been issued more than 12 months ago, you need to reapply for a new warrant. My advice that I've given on that is yes, that's correct, and it seems to reflect the court rules which are imposed by CPR 83.3 subsection 3. I draw your attention to 83.3 subsection 4. You're getting lots of numbers thrown at you, apologies. What that does is it provides a procedure whereby the landlord can apply to extend the existing warrant rather than have to pay the fee to issue a new one. Now, in my written answers, I think I had said, well, if you have to make an application on the papers, ultimately, I'm not really sure whether or not you will save on fees. But Sarah Williams, very helpfully, has copied some information from Clerkenwell and Shoreditch County Court, where they're saying that if you make that application before the 31st of August this year, they will not charge a fee for the application to extend the existing warrant. So I think that's a purely administrative matter. If your possession order is still valid, I can't see why you wouldn't be granted that extension. Bear in mind that possession orders and warrants need to be enforced within 6 years. So if you've got a suspended possession order or some sort of unusual order more than 6 years old, which you want to enforce, slightly different situation would apply. I suspect you can make a paper application which will be listed for a hearing in that case, and you'll need to explain to the court why you want to enforce that order. But generally, it sounds like there are procedures in place to deal with that. In terms of other questions which have come up, I'm trying to keep an eye. One really useful question which was asked in relation to breathing space, going back to Christina, there were several questions about breathing space, but I thought one was particularly useful in that it simply said, well, if a breathing space applies and somebody owes me quite a lot of money and isn't paying their rent, then what can I do as a landlord in practical terms? And I thought Christina gave a very good answer to that. And I thought it might be useful to allow her to elaborate on that or to draw her answer on that to everyone's attention. Still on mute, Christina. There you go.
Yeah, sorry, I lost the webinar for some reason. So essentially, you can. I think the question related to ongoing liabilities, is that the one that you were referring to, Tara, or is it the one that referred to what happens after the breathing space comes to an end?
So there was a question from Debbie Libourd, if I'm pronouncing your surname, Debbie, correctly, apologies. What can you do in practical terms if someone doesn't pay their ongoing liabilities, i.e. current rent?
Right, yeah. So I think the answer I gave there was that for ongoing liabilities, it is perfectly fine to contact the debtor because that's not captured by the sort of prohibition, as in you can contact them to discuss that. You may also want to speak to the debt advisor to see if that is something that can potentially be taken into consideration, because the whole idea behind this scheme is that somebody gets professional help to assist them with the repayment of debt. And obviously, if there are other obligations that they are subject to, that can be taken into account. So you can either speak to the debtor directly, because it's an ongoing liability, it's not a debt at that point, or you can speak to the debt advisor. I can't find the question, so I'm not sure whether there's anything else that I had to say about that, Tara, that you thought was particularly helpful. But I think that's the gist of my answer.
Great, thank you, because I imagine that's just the question that will be at the forefront of, certainly from a landlord's perspective, is the question of, well, what happens if there's a really serious breach of tenancy agreement, for example, during the breathing space period. There's one other question which you might know the answer to, which is, can defendants apply to extend their breathing space?
So I think I sort of answered that one indirectly. So the standard breathing space, the one for 60 days, I don't think that can be extended, and you can only have that once during the during the year. The mental health breathing space, that isn't so much dependent on fixed days or times, but that just principally relates to how long somebody is undergoing treatment for. And so for that one, that's more of a sort of flexible one, if that makes sense. So there they wouldn't officially apply to have it extended, but then if the crisis treatment takes longer, it would persist for the entirety of that time, plus 30 days after that crisis treatment having come to an end.
Okay, well, thank you very much. We're up to 12:05. We've done our best, I think, to answer the questions that have come up in written format, and I hope anyone who wants to has managed to take a quick note of those. Just a reminder to everyone that this recording of today's webinar and also the slides will be available online later on somewhere on our website, I suspect within the next couple of days. So please do feel free to share them with any of your colleagues who were unable to attend today or might be interested. We've also given you there our contact details for our clerks. Our clerks always love to hear from you, as do we. So please don't hesitate to get in touch if you have any queries or comments. And we very much look forward to hopefully seeing you all again soon, in person maybe, if not online. All right. Thank you all very much, and have a nice day.
Thank you.